This presentation describes the legal framework under which electric utilities in Kentucky are required to maintain adequate generating capacity and plan to meet future needs for power. It also describes the process those utilities must go through before the Kentucky Public Service Commission in order to construct or acquire new sources of electric power. There are two regulatory processes that govern electric utilities with respect to the adequacy of generating capacity. The first is the requirement for Integrated Resource Plans, also known as IRPs. The second is the Construction or Acquisition Certification process, known formally as the Certificate of Public Convenience and Necessity, or CPCN. These processes are governed by statute or regulation. The IRP process is delineated in Kentucky regulations. The CPCN process is governed by Kentucky statute and regulation. Both processes are also guided by precedents set in Kentucky Public Service Commission orders and through legal actions in the courts. Now let's look at each one in more detail. Kentucky law broadly requires utilities to provide adequate and reliable service to their customers. That means that electric utilities must have power supplies sufficient to meet the needs of their customers. This includes maintaining a reserve margin for contingencies, such as an unexpected shutdown at a generating facility. Utilities can choose to maintain adequate generating capacity by building or purchasing power plants that they then own and operate, or through purchases of power from a third party under a firm long-term contract that assures a reliable source of power. The IRP process requires utilities to forecast demand and supply every 3 years. If supply is not adequate to meet projected demand, with adequate reserve capacity as well, the utilities must provide plans for balancing the two. In recent years, the PSC has directed utilities to place equal attention in their IRPs on reducing demand through energy efficiency improvements and other measures, as on increasing supply. Any projects that seek to add generating capacity must be consistent with the utility's current IRP. Before we examine the process for adding new generating capacity, we will look at the retirement or closure of existing power plants. Kentucky law does not require a utility to seek prior approval from the Public Service Commission before it shuts down any existing power plant. Utilities may choose to close a plant for any number of reasons. Older facilities may need to be upgraded in order to comply with environmental or other requirements that were not in effect when the plant first went into operation. A utility may determine that it costs less to close the plant and replace the power than to construct the required upgrades. Even if upgrades are not required, older power plants may become obsolete, inefficient, or simply too expensive to continue maintaining and operating them. If a utility's need for generating capacity is reduced, either through the loss of customers or because of improvements in energy efficiency or other factors that reduce demand from existing customers, some generating capacity may become unneeded to meet the utility's needs. In that case, the utility may try to sell the power elsewhere, but if that proves impossible or uneconomical, it could choose to retire some generating capacity. Although the Public Service Commission regularly reviews electric utility IRPs to make sure that power supply is balanced with demand, it does not have a direct role in a company's decisions with respect to the retirement of a specific electric generating facility. However, that does not mean that the Public Service Commission is unaware of these decisions or uninterested in them. As noted earlier, the PSC has broad authority and responsibility to make sure that utilities maintain adequate generating capacity. Therefore, the Public Service Commission can, on its own initiative, investigate the impact of a power plant closing if it believes that such a closure might affect the utility's ability to meet the requirement to provide adequate service. If the Commission were to find that a utility lacks adequate generating capacity to meet current or projected demand, it could order the company to take steps to remedy the situation. Similarly, the Public Service Commission can examine a utility's decision to determine the effect it would have on the rates paid by a company's customers. If the PSC were to find that a utility has acted unreasonably, it could order corrective action to protect the company's customers. Utilities generally seek to add generating capacity for one of two reasons: to replace facilities that are going out of service, or to meet demand projections in their long-range plans. Utilities have several options for adding capacity. They can choose to construct new power plants that they will own and operate. They can lease or purchase existing facilities from another company, or they can enter into long-term contracts to purchase power from a third party. If an electric utility wants to build or purchase a power plant, or any other major facility for that matter, it must seek approval from the Public Service Commission by applying for a Certificate of Public Convenience and Necessity, or CPCN. In other words, a utility cannot simply go ahead and build whatever it wants, whenever it wants. The CPCN statute is very general. It simply states a requirement for approval of new facilities, but does not set forth any criteria for the Public Service Commission to use in reaching a decision. The details of the process have evolved over the years, largely through precedents set by a series of court decisions. In general, the first hurdle for a utility to clear when requesting a CPCN for new generating capacity is to demonstrate a need based on existing or forecasted supply and demand. The utility also must show it has considered a range of reasonable options to meet the existing or forecasted need. When assessing whether options are reasonable, the PSC considers factors such as economic viability and technical feasibility. Reasonable options that a utility may consider include several that would require a CPCN. Construction of various types of new facilities. A utility may consider a range of generation technologies that use a variety of fuels. Purchase or lease of existing generating facilities. A CPCN application also may include evidence that a utility has considered other reasonable alternatives that do not involve construction or acquisition of new facilities and may not require a CPCN. These could include purchasing power from a third-party provider or reducing demand and the need for new generating capacity through measures such as energy efficiency improvements in partnership with customers. Third-party purchases or comprehensive energy efficiency programs require PSC approval under other statutes and regulations. The CPCN process also guards against wasteful duplication. This principle is based on a court case decided 60 years ago, which recognized the PSC's authority to protect the ratepayers against the construction of unneeded facilities by utility companies. Thus, in seeking to add generating capacity, a utility may not overbuild or incur unnecessary costs. The prohibition of wasteful duplication gives rise to the principle of least reasonable cost. This means that a utility must show that the option it has chosen for adding generating capacity is the least expensive among the various reasonable alternatives that it has considered. Least cost does not simply mean the lowest upfront expense to build or acquire a power plant, or to acquire power or reduce demand. It also takes into consideration long-term factors such as the cost of operation, stability of fuel supply and fuel costs, reliability and cost stability of purchased power supplies, costs of borrowing money, and other factors. The Public Service Commission takes all of these into consideration in determining whether an electric utility has selected the least cost reasonable option for meeting current and forecasted power needs. If the PSC determines that a utility has met the criteria for receiving a CPCN, it will grant the certificate. Once the PSC grants a certificate, the utility has a presumption that its reasonable cost of construction and acquisition may be recovered through rates once that facility is in use. Kentucky law does not set a time limit on the Public Service Commission's consideration of an application for a CPCN that involves construction or acquisition of new generation capacity. Construction of facilities built solely for the purpose of environmental compliance fall under another statute and may be subject to a 6-month deadline. Once a CPCN has been granted, the utility has a year to begin construction or to complete an acquisition. Other parties may seek to intervene in the proceeding before the PSC. Only the Kentucky Office of Attorney General, as the legally designated representative of the ratepayers as a whole, has an absolute right to intervene. Other parties may be granted intervention by the PSC if they can demonstrate that they have a unique interest in the case and can provide information that might not otherwise come to the PSC's attention. Intervention allows a party to present evidence and engage in discovery, as well as participate in any hearing before the Public Service Commission. Interveners generally must be represented by a lawyer. The PSC may hold a hearing on a CPCN applications. Hearings are much like a court proceeding and are held at the Commission offices in Frankfort. They are open to the public and are broadcast live via the web at the PSC website, psc.ky.gov. Case records are also available on the website. Public comments are taken at the beginning of the hearing. The PSC also may choose to hold public meetings for the purpose of receiving public comments in communities affected by a particular case. Public comments also may be submitted in writing to the PSC. Here is how to submit written public comments on a case before the Kentucky Public Service Commission. Always try to include the case number so that your comments may be directed to the proper case file as quickly as possible. Here is who to contact if you want more information about the CPCN process or any case pending before the Public Service Commission.